Okay, let's go straight across to Deepak joining us live now on the Buck Stops here. Thank you very much, Deepak, for speaking to us. You know, critics of all the protests that have been taking place are regularly arguing that Article 15 guarantees that there is no discrimination based on caste. The UGC regulations were brought in for that on the instructions of the Supreme Court. Then the primary protests, what is the logic behind them?
So first of all, let me start with an apology that I'm having to engage with you on the move. I'm on the way to the airport. I'm stuck in Bangalore traffic, so my apologies for that. See, the issue is this. Let me just give you some history so that you have a clearer picture as to what's happened. You had a UGC regulations of 2012. 2019, post the Payal Tadvi case and the Rohit Vemula case, petitioners approached the Supreme Court saying that the UGC regulations of 2012 are not being implemented properly. And the underpinning of the case was that both the deaths of Rohit Vemula and Payal Tadvi was a result of caste discrimination. That was the statement and that was the claim made in court. Therefore, the then bench comprising of the current Chief Justice, who was not the Chief Justice then, Honorable Justice Suryakant, basically said that UGC regulations cannot be a symbolic measure. You will need to implement it better. So let's look at the question of implementation. So the question was not of the inadequacy of the structure or the definition. It was a question of implementation in terms of allocation of resources and formation of committees on campuses. This is how the matter started in 2019. 2019 until 2025, it's practically in a deep slumber and the matter is lying in cold storage. 2025, suddenly the matter again gets taken up. And at this stage, the government of the day presents a very balanced version, draft regulations of 2025, which basically provided for 3 safeguards and salient features. 1, that malicious complaints and motivated complaints will be prosecuted. Both parties will have the right to lead evidence to dispel or repel each other's contentions. 3, stakeholder committees will have representation from across the board, not just the so-called affected communities. And 4, there was no attempt to increase the definition or expand the definition from SC/ST to OBC also. And there's a reason for this. Because SC/ST Atrocity Act has some kind of a putative history, which we have come to accept. That's a different issue. OBC reservations have been introduced primarily on economic basis and socially backward positions, not because of any particular history beyond that. Therefore, you don't have let's say, an OBC version of the SC/ST Atrocity Act in the first place. You understand what I'm saying? Therefore, there was no need to expand even the definition. Now, when this was happening, what is it that led to the drastic change from the draft of 2025 that was presented by the government in the Honorable Supreme Court to the regulations of 2026, where there's a sea change? The safeguards are gone and the definition has been expanded, and it is almost as if you're creating a Gestapo on campuses. My apologies for using that language. Okay? And there is a complete exclusion of a vast swathe of a class of people who belong to this country across religious, let's say, identities, which is the general community, the so-called non-reserved community. Obviously, therefore, parents will be worried about sending their children to college campuses and even school campuses here. Who knows what will happen next, right? So the basic question that people should be asking is, if there was already an SC/ST atrocity legislation in place, which does not exclude campuses from this kind of a discrimination, where was the need to come out with the 2012 regulations in the first place? So the story is, from decent, it was supposed to become better. It has become worse. From 2012, it should have gone to 2025 draft. Instead, it has gone down the path of 2026 UGC regulations. That's the long and short of it.
Except 2 things happened, that the OBC students groups, they said we also should be included because anecdotal data suggests that there are atrocities against OBCs as well. It's not just limited to SC/STs, also OBCs should be included. That is what changed.
So here's the problem. Therefore, is the government going to take a position? Those who don't represent it will not be represented or considered in the definition? It can't be a situation of jiski lati uski bhais. No, that can't be the argument. So let's assume that you don't have people from the general community representing their interests before the committee. Does it mean that it gives you the right to come out with a definition that excludes them from the scope of discrimination? I can tell you the number of instances that I have faced on college campuses for my Brahmin identity in Tamil Nadu. Okay? That's a state with a particularly peculiar history when it comes to my community. What happens there? So therefore, if those regulations were actually introduced, a situation that is already bad for the Tamil Brahmin community in Tamil Nadu would have become even worse thanks to this campus regulation. And this was when I was, as an engineering student, I faced that. So the point is, if the argument cannot be that somebody chose to present their point of view, therefore they were represented and their point of view was considered, and therefore the others cannot be considered. You're a government, for God's sake. You have a duty to be equal across the board, regardless of representation. I don't buy that argument, I'm sorry to say.
But Indra Jaisingh is arguing that when you say jiski lathi uski bhais, lathi aapki hai. Upper caste, what are they crying about? For years and years, they have wielded the lathi and they have had the bhais.
That narrative is way past its sell-by date. And when people start revisiting the history of caste atrocity literature in this country, they'll be shocked. The less said, the better on the subject. But if this was a Congress government in place, I can understand them buying this hogwash, lock, stock, and barrel. But it's a non-Congress government which shouldn't have gone down this path. Second, Ms. Jaisingh's position actually is that even the 2026 regulations as they stood were inadequate. So what am I supposed to say? If they were inadequate and she wanted even more problematic, let's say, positions incorporated legally, then I don't know what is it that people were batting for? To turn every campus on this country into pre-2014 JNU. That can't be the situation.
Is this a preemptive outrage?
We wanted lesser.
Is this a preemptive outrage driven? Is this a preemptive outrage driven largely by the upper caste? Because that is the color and the feeling that this is all the Brahmins, Thakurs, Banyas getting together because they find their hegemony challenged at this point.
One, if Brahmins, Thakurs and Banyas get together, there's nothing wrong. Just as everybody else can band and bond together, so can Brahmins, Thakurs and Banyas. So let's not actually say that they are not supposed to get together. Everybody has the right of association under the Constitution to protect their interests. Point number one. Point number two, preemptive would mean taking an action even before the regulations are come into effect. Has that happened here? It's not as if these instances of protest have been going on since 2025. They've started only... No,
because the minister said that we will not allow misuse. The rules exist, so you should not preemptively fear they are going to be misused. Otherwise, there should be no law at all. Any law can be misused.
As a student of constitutional law, I can't think of a single principle where executive assurance can prevail over fundamental constitutional infirmity. If there is a fundamental problem in the definition, assurances cannot actually act as band-aids over a cancerous problem or a cancerous definition. Okay? So that doesn't cut ice. And I'm not going to single out any particular individual or ministry. Everybody speaks on behalf of the Union of India when they defend it, period. Therefore, the Union of India cannot take that position and say, we will give you this assurance. What ashwasan and assurance am I supposed to take to college campuses and police stations? How does it work? I'll give you a simple example. I've given this example on your show even before. Even after Section 66A was struck down by the Supreme Court through the judgment in the single case, remember what happened? Police stations were still registering affairs under Section 66A. That was the situation in the country. So you're telling me a law which has been struck down is still going to be implemented by our police stations, but there is no scope for abuse of an existing provision. That is the status of our justice system.
Let me reverse the logic. Many men argue, and there are many men's rights organizations who argue against the Domestic Violence Act or the Anti-Dowry Act, and they say that now men are victimized under the DV Act. However, that shouldn't mean that the DV Act, which has been called draconian by many, should be done away with. Then can a similar logic be applied to this as well? It may seem draconian to some, but is that reason enough to do away with it or to water it down?
So let me answer the question. Firstly, it is the Supreme Court which has categorically recognized in multiple judgments of the abuse of even 498A. This is not my statement. Supreme Court has recognized it. And therefore, the Supreme Court itself has said, one, whether it comes to rape laws or let's say molestation laws or sexual harassment laws or any kind of domestic violence laws, let's make it gender neutral because domestic violence is no more a one-way street. Point number one. Second, if there is every law, even a decently drafted law, is capable of misuse, that doesn't mean you have to scrap the law. That's not the argument. But if inequality and potential for abuse is rife and on the face of it there's a problem, you can't compare that with an abuse of a good law or a decently drafted law. That is the distinction here.
Okay.
Here, the definition is fundamentally problematic.
Okay. What within this this regulation as it exists needs to be done away with? Do you think at least the draft regulations that have been brought in earlier, where OBCs were not included, where you had the right to go and file complaints if there was a false allegation against you, that was preferable, that was acceptable? What should be done to make this acceptable?
The simple position is this. You can take a blanket position against any kind of discrimination, have a policy of non-discrimination as a part of your standard operating guidelines across campuses, and there's no problem with it. Okay? We are just saying, don't incorporate a framework where there is a fundamental presumption in favor of some and a presumption against some. That's it. Now, coming to the question of protecting SC/STs on campuses, there is a law, which is the SC/ST Atrocity Act already. Now, someone should point out and tell me that campuses are those no-go zones or free zones where the SC/ST Atrocities Act does not apply. Can someone point this out to me? Agar aisa nahi hai, then clearly the SC/ST Atrocity Act applies across the territory of India, and no campus and institution is an exception to it, right? Which is why my fundamental position is, why did you need the 2012 regulations in the first place if the intention was to protect SC/STs only? Because then you have a legislation for it. You don't need two laws to address this point.
But isn't it like you have laws against rape and sexual harassment across the country, and yet in individual offices and campuses you have Vishaka committees, you have posh guidelines? It's something like that.
I'm so grateful. So the point is, then you come out with a delegated legislation under the SC/ST Atrocity Act saying that this is how it will apply on these campuses. You don't need a separate set of regulations for it. And UGC regulations were not that about saying that this is required under the SC/ST Atrocity Act. It's a separate standalone creature in itself. So let's say you're talking about the prevention of sexual harassment law. It casts a requirement on every office space to say you will do this to prevent if the number of employees exceeds so and so. This is how it will be constituted. You have to then basically say these campus guidelines are pursuant to the requirement under the SC/ST Atrocities Act. Is that the argument being made today? No. The UGC regulations are being treated as a standalone creature independent of the SC/ST Atrocities Act, which means you have two instruments acting for the same issue. Why?
All right, we're hoping that the answer will come from the government and the UGC, which in its wisdom has brought in those regulations. At what stage did this happen? Who made that ultimate decision? We'll wait for those answers. For the time being, Jay Sai Deepak, thanks very much for joining us.